When different parts of your business carry different risks, keeping them in one entity means a problem in any one of them can reach everything else you own. Step 1. Identify where your liability actually comes from. Not every activity carries the same risk. A client-facing service business carries contract and professional liability risk. A business that sells products carries product liability risk. Owning real estate carries premises liability risk. Having employees carries wage, discrimination, and termination risk. Handling client funds or sensitive data carries fiduciary and privacy risk. Each of these has a different claim frequency, a different potential size, and a different structural response, so the first step is an honest look at where your specific risk is coming from. Step 2. Separate your operating entity from your holding entity. The operating entity is the one doing business hiring, contracting, generating revenue, and taking on the liability that comes with that. The holding entity owns the valuable assets the operating entity uses: real estate, equipment, intellectual property, investment capital. The operating entity leases or licenses what it needs from the holding entity. Done properly, a creditor of the operating entity has no recourse against the holding entity's assets, but only if the two are genuinely separate, with their own accounts, real capitalization, and documented, arm's-length agreements between them. A holding entity that exists only on paper won't survive a court's scrutiny. Step 3. Separate your operating lines from each other. If you're running a consulting practice, a technology product, and a real estate portfolio through one LLC, a judgment against any one of them can reach the assets of all the others. The fix is giving each significant activity its own entity: consulting in one LLC, the product in another, real estate in a third, sometimes with a holding company owning all of them. That structure means a judgment against one line generally can't touch the assets of the others. Step 4. Treat real estate as its own structural question. Property generates its own liability through premises claims, environmental issues, and landlord-tenant disputes, while also being a valuable asset you want to protect from your operating business. Holding each property, or a small related group, in its own dedicated entity protects the property from the business and the business from the property. With multiple properties, you're trading off simplicity against separation. A single multi-property LLC is easier to run, but a judgment on one property can reach the others. Grouping properties by location, risk, or financing can strike a middle ground. Step 5. Think about employment risk structurally, not just as an HR issue. Wage and hour claims, discrimination claims, wrongful termination, and workers' comp are frequent and unpredictable. Some businesses use a dedicated employment entity or management company to employ the workforce and separate that liability from the operating business's assets, though this needs careful implementation to actually hold up and to comply with employment law. Step 6. Maintain the separation because it doesn't maintain itself. Every entity needs its own accounts, its own contracts, documented intercompany arrangements, and its own governance. If your entities are run so interchangeably that they function as one business, some states allow a court to treat them as a single enterprise for liability purposes, collapsing the exact protection you built the structure to create. A periodic review with legal or compliance advisors is what keeps that from happening. Subscribe for more practical guidance on structuring your business to contain risk before it spreads.